Yeah, there are some remarks which I want to state to state before we start. These arise from the fact that yesterday any intelligent person could have seen that the proceedings yesterday, they left much to be desired. And further that when we concluded or postponed the matter, it was obvious that there was acrimonious exchange between Ms. Colonel Stein and Advocate Mnisi. And I thought it is proper, as a presiding officer, in adjudicating this matter, to set down the principles which govern the precept concept of cross-examination and the response from a witness and the question asked by counsel. Unfortunately, these are the precepts, regulations, concepts, customs, and conventions which apply until maybe, as people are saying, we change the law in South Africa into what people are calling African law. But unfortunately, the law as it obtains today is formulated under our Constitution and even under our Criminal Procedure Act, which we all know was written by Yemstra initially. We used to use Wigmore, who's an English jurist, but subsequently the late Judge Yemstra coordinated these laws and drafted what was referred to as the Criminal Procedure Act, which, as I say, incorporates a modicum of how cross-examination should be conducted and how a witness should be treated, how counsel should be treated, and how court officers should exercise decorum in this court. Normally, these things are said at the end of the case, when a court is writing its judgment. I've used in this context Wigmore on criminal law, Detroit, and Himstra. And I've summarized what they have to say about the conduct of cross-examination in a court of law. You'll interpret after I'm finished, okay? It is tried that in terms of Section 166, a witness may be cross-examined. But cross-examination in terms of the Criminal Procedure Act and in terms of Section 35 of the Constitution is not an absolute right. It's not an absolute right. Like all rights in our Constitution, they are limited by set exigencies. The authors basically say that it is a right of an accused person through his counsel to cross-examine a witness who is called by the state. But then the injunction is that the court will, of course, guard against inadmissible questions. And they say that the substance of the questions is important, not mere words. Even tone of voice can transform an apparently proper question into an improper one. And then they quote the case of Schmidt. They quote Schmidt, who's a writer. And they also quote the case of S versus Aitken, and another 1988 4 SA 394 at 397E is a Cape case. And they say the paragraph in Wigmore referred to the uses or the usual sources of the reference in this regard, where they are saying that even a question which is innocuous, depending on the tone in which it is said, uttered, or stated, it may be improper, or it may become improper. The purpose of cross-examination is to discover the truth. It is accepted in our criminal procedure as a test without equal for the value of oral evidence, even if it is sometimes wrongly used and even abused by legal practitioners. And it's not me saying that. I'm reading from a book. I'm not the law. I'm reading from the book. In S versus Trele, 1965 1 SA 82A, which is the leading case in South Africa regarding cross-examination, conduct, mores, decorum, and dignity. It's a 1965 case, 1965 1 SA 82, Appellate Division at 91B to D, Wigmore at paragraph 1367. It is therefore grossly unfair not to allow cross-examination. It is also irregular not to allow cross-examination, especially for unrepresented accused, within limits of fair cross-examination. Cross-examination is expressly not limited to topics raised in evidence in chief. In a criminal case, within the standards of reasonable doubt and trustworthiness, it is often more important and at the same time more difficult to expose. Honest witnesses may make mistakes. The law of procedure allows cross-examination great latitude to investigate any relevant topic. But cross-examination should never degenerate into a heated quarrel. Cross-examination does not mean examining crossly. The questions always retain objectivity and professionalism as an officer of the court. For instance, a simple thing like the dignity of a witness, it has to be preserved. And even our Constitution talks about dignity in Section 10. This witness, he's a colonel. He's Colonel Steyn. He must be addressed as such. And it is not me saying that. It is the law. When a doctor comes to give evidence in court, you refer to that person as Dr. So-and-so. And I've heard advocates in this court telling witnesses, hey, I am an advocate. They're correct to say that. Even under the apartheid government, when Mandela, the president, was giving evidence in the case of state South African Rugby Union in 1995, I think, when he was called by Judge Viljoen, they called him President Mandela. That judge, although he was not of the same sound opinion as Mandela, he still referred to him as President Mandela. So this witness in this court, he is Colonel, and I'm not saying this facetiously, he is addressed as Colonel Steyn. When he gave evidence in this court, he was referred to as Colonel Steyn. When House gave evidence, he was also referred to as a Lieutenant Colonel. That's what the law says. And this is categorized under what they call courtesy, the requirements of courtesy. In HIMSRA, page 166. The question may never go outside the bounds of, the questioner may never go outside the bounds of decency. Where the limits may differ from one witness to the next, but courtesy is always expected from an officer of the court, like advocates, even the judge. Furthermore, courtesy costs nothing, and practitioners owe it to the court and every witness. You can see the case of S versus Azau, 1974, 1 SA 808, Transvaal, at page 810G. The dignity of a witness may never be ridiculed. See in this respect S versus Tswai, 1988, 1 SA 851, Cape. The courts warned against the tendency of cross-examiners to sneak in personal opinions on the witness's credibility, including crude variations such as, now you are lying. Not only is behaving in an insulting manner towards a witness an abuse of the right of cross-examination, it is also a contemptuous assumption of the court's function as sole arbiter of credibility. The cross-examiner should never tell a witness that he or she will argue at the end of the case that the witness' answer should be rejected for the reason explained to the witness in putting the question. Everyone is entitled to be addressed by his or her surname and title in court. The use of forms of address such as witness, accused, etc. are disapproved of. You can see this, the case of S versus Gwebu, 1988, 4 SA 155. And also the case of S. Gulaqe, 1991 SACR 101A at 103F. It is simply not acceptable to address an adult by his or her first name. In Tswai, the court pointed out that especially the humble amongst us should be treated with respect and understanding, with respect and correctly and timeously admonition or timely admonition. Fairness. The cross-examiner may never exceed the limit of fairness. This applies to all cross-examination. Even the prosecutor is admonished that he should guard against excesses, particularly when an accused is not legally represented. In the case of S versus Nchoni, 1987, 2 SA 671, Orange Free State, unfair cross-examination of some accused affected the fairness of the trial and the other accused to such an extent that several convictions were set aside in review. In S versus Nkabinde, 1989, 2 SA 421, a conviction was set aside because of, inter alia, the irregular manner in which the accused was intimidated, insulted, ridiculed, belittled, and confused in cross-examination. The failure by the magistrate, even the failure by this judge, to stop the unfair cross-examination was found to be fatally irregular. In Ntsani, it was also stressed that a presiding officer should repeatedly, if need be, stop unfair questioning or statements to witnesses that a presiding officer finds inappropriate. And it was also stressed that the presiding officer should repeatedly, if need be, stop unfair questions or statements to witnesses. Unfairness, of course, does not only mean the type of violations mentioned above. Inaccurate statements, for instance, concerning the other witness, are also unfair. What is more, muddled the search for truth. That's what they do. Elaborate, vaguely formulated, two or more multifaceted and argumentative questions perhaps cause heat but shed no light. Above all, such questions are unfair to the witness, especially when a person who uses the shotgun method of questioning, who is so keen to accuse the confused witness of evasion. Cross-examination is not meant to be a test of stamina. I once said this. See in this regard Africa Solar Pty Ltd, Diwadi Pty Ltd, 2002, 3 All South Africa, SA 369, it's an SCA decision. Fairness also requires that the honor of a witness not be attacked in argument when there is no opportunity in cross-examination from him or her to react to such accusation. They quote the case of President of the Republic of South Africa and others versus South African Rugby Football Union and others, 1999-10. It's a Constitutional Court case, 2000 SA, at paragraph 61 to 63. And they also quote the case of S versus Buzak, 2003 SA 381 SCA, at page 51 to 54. Honesty. Obviously, the cross-examiner may never cross the limits of honesty. A witness may not be misled. No untrue statement may be made to a witness. Statements as to what other witnesses might have said must be accurate. If a cross-examiner is not certain whether an allegation by another witness has been correctly remembered or recorded, he may or she may not put it to the witness before clarifying same. Questions may not be formulated in such a manner that they appear to be statements of fact that witnesses made, where such so-called facts do not form part of the cross-examiner's case and will not be given in evidence. The other issues I'll go to inadmissible evidence. Cross-examination based on inadmissible evidence is not permitted. Examples of such inadmissible evidence are a confession which was excluded, for instance, as being inadmissible, etc. Inadmissible evidence may also not be introduced under the cloak of cross-examination. They quote the case of S versus Nkwanyana, 1978, 3 SA 404 Natal. And then they talk about principles under cross-examination. A trial is not a scientific experiment where certain reactions lead to exact results. It is a fallible process which attempts to form a view with reasonable confidence. Cross-examination, an aid in that process, employs several methods to test reliability of factual findings. One such method is to weigh the relative merits or different versions of facts against each other by bringing them into confrontation with each other. And they also talk about curtailment of cross-examination. And this is Himstra. General curtailment of cross-examination. It is a fact of life that protracted and apparently irrelevant cross-examination is a problem with which the presiding officers have to contend with. On the one hand, cross-examination is an indispensable component of the criminal process to advance reliable adjudication of facts, which, for reasons of principles and pragmatism, is entrusted to the parties. In an accusatorial process, the parties decide which evidence to present to the adjudicator of facts, meaning the judge, whether in writing or orally, or in cross-examination. This is their right and duty. They may have information at their disposal of which the presiding officer was not knowledgeable or has no knowledge of. which she would in all probabilities would otherwise never have had. The parties may have the aim with their questions about which the presiding officer knows nothing and does not need to know. To a large extent, therefore, the presiding officer has to depend on the parties regarding the presentation of evidence. Here they warn judges that the measure is not about boredom or impatience of the judicial officer, irrespective of how prolix and even apparently misplaced a cross-examination may test a judicial officer. Irrelevancies can always be ignored afterwards. On the other hand, one can only speculate about the possible importance of particulars which remain unhidden in the proffering of the evidence. It certainly does not mean that boundless cross-examination is allowed. Where the credibility of a witness clearly is not in issue, the question may certainly be asked that is intended, of what is intended. In the absence of convincing explanation, curtailment will be in order. Also, if the court is, after judicial consideration, considering granting the right to explain the purpose of the questioning, and is convinced that one or more of the factors mentioned in Cele are present, an appropriate absolute limit may be set. They repeat again that cross-examination is not meant to test stamina. Although the court can intervene against cross-examination, the only apparent purpose of which is to tire the accused or a witness, curtailing cross-examination which is intended to traverse again evidence which already given may constitute an irregularity. Like this witness. This witness was called here, as I proposed, in a circumscribed fashion. 3 issues he had to enunciate. I won't mention what other cross-examination he was taken through. This may be interpreted as amounting to the gagging of the defense. For instance, in S versus Ngogula, 1979, 1 S8 3525 in the Transkei. The conviction was set aside because the magistrate did not allow the accused to ask questions about something the latter had said in his evidence in chief. The trial court may, however, prevent unnecessary repetition. If you see, this case is S versus Green, 1962, 3 SA 886, Appellate Division. This case was written by Falam, who conducted the Marikana inquiry. He was in the SCA, retired. Once it has been determined that a certain question or line of questioning is irrelevant, it must be prohibited. If, for instance, an accused wants to go through notes in a state witness's notebook which have nothing to do with the case, it is irregular for the court to refuse to allow such a diversion. The court, questions by the court may intervene at any stage with questions for elucidation, but must not take over the role of the questioner. The court must not ask leading questions to strengthen the state's case. I was accused the other day of colluding. In R versus Lopsha, 1926 AD 276 at 281. At R versus Ngobo, 1925 AD at 561. This is where they talk about judges who take over and become prosecutors. However, leading questions as such are not irregular if they are not put evenly at the end of the mutual questioning. Persistent and searching leading questions by the court to an accused may, on the other hand, be a factor which, together with other, amounts to an irregularity. And the case of R versus Bartman, 1993, SA 535A. Where they talk about the fact that the court must not conduct in questioning in such a manner that its impartiality can be doubted. The court must not take part in the case to such an extent that the court obscures the points in issue. The court must not intimidate or upset a witness or the accused to such an extent that the answers are weakened or credibility degraded. And this applies also to the defense counsel. This witness yesterday wanted to get out of court and leave. I don't know why he did it. He didn't do it. And Mr. Mnisi sat down and said, "You can go." It's a court of law in South Africa. Although the court is entitled to follow its own line of inquiry, which leads to the end of the case, a conviction, or as was stated in declared 1930 AD 308, the presiding officer should not get involved in lengthy questioning of cross-examination and certainly not in instructing the prosecutor or even the defense how to run the state's case or their case. That's why yesterday I gave certain of my colleagues here the case of S versus Cooper, because I didn't want to intervene and say that question is irrelevant. Read S versus Cooper, 1976. It tells you about what is irrelevant or not irrelevant. And it talks about the proximate or utmost questions you can ask concerning a particular aspect. Yeah. Further, they say in the case of Kiabela, it was stressed that impartiality, judicial fairness, and dignity should be the hallmark of judicial proceedings. To avoid that the proceedings are tainted by impropriety. And they quote the case of S. Dalinjevo, supposedly some chief or king in the Eastern Cape, 2016 1 SACR 329 SCA. And they also address this question about the court itself may call a witness in terms of 167 or 186, which I addressed the other day. But it's important just to mention that they say that where the court has called a witness in terms of 167 or 186, it is not said that the court will be allowed to cross-examine such a witness. The court is not allowed to cross-examine any witness. Although it is not said which party will be allowed to cross-examine on what basis of the leave will be granted or refused, it is submitted that both questions will be answered on the grounds of fairness. In other words, the party for whom the witness is unfavorable will be granted leave to cross-examine. Like I said, this witness, if he's called here, where the state was accused of bringing evidence through the back door, and I quoted a case here which related to Judge Seriti, who refused to call a witness when an application was made by the state that this witness must be called to explain and elucidate certain aspects of the evidence. And he refused. And it was held that by the SCA, not me, Carol Lewis was one of the judges who wrote the judgment, that where a judge refuses to call such a witness, he errs. But not only does he err, he commits an irregularity. But not only is that irregularity which he commits, that irregularity is so gross or grave that it impinges on the administration of justice, or it impinges on the fairness of the trial. Because as we know, not all irregularities vitiate a trial, not all. I can commit 20 irregularities. It doesn't follow that justice has been denied to a particular litigant. It is only when the irregularity is so gross that it impinges on the fairness of a trial, and that the administration of justice can be said to have not happened. So those are the remarks. There are others. I didn't sleep. I read this whole book last night because I was worried about the conduct which happened in this court. And it's not me saying that. There must be decorum in court. A witness must be accorded the space and the dignity and a witness also has to answer to the best of his ability all the questions asked. And all of us must show each other respect, decorum, and deference, because we are all about the same thing here. We want the truth to come out of any case which we handle. Okay, thanks. You can interpret what I said.
Inkantolo ithi nje ayiphawuleke noma isho amazwi ambalwa ke mayelana naloko okwenzekileke izolo, ngoba becacileke kuyena wonke umuntu ohlakaniphileke ukuthi bekhona nje ukushayisana ke kwamazwi okungekuhle phakathi kwakhe ke uadvocate umnisi kanye naye uKenneth Stein owufakazi la kangangokuthi uze wacela ke gcineni ufakazi ukuthi ke inkantolo ayimdedele ahambe ngoba ke yena ke esithi cha lokho kwenzeka lana ke akwenzeki ngendlela ke noma ke ebona ukuthi ke yena ke manje akasahlonipheki. Inkantolo isize yafunda ke kwincwadi yomthetho eshoyo ke ukuthi ibhalwe uyena uHimstra, iyaphawula ke nangaye usection 166 la eshilo khona ukuthi ke ufakazi yebo kufanele ukuthi ke abuzo noma ke ahlonywe ngemibuzo nanjengoba usection 35 naye ke esho, kodwa ke ethi lelo akusilona ke ilungelo ongathi ke ilungelo ekuyilona lodwa noma ke elugcina ke futhi naye ke ummangalelwa unalo ilungelo ngayo ummeli wakhe ukuthi ke ahlome ufakazi ngemibuzo kodwa ke nenkantolo ke kufanele ibheke ke uma kwenzeka ke lokho ukuthi kungabuzwa imibuzo engafanele ukuthi ke ibuze noma ke imibuzo ezophatha kabi ufakazi. Yasho ke nokuthi inkantolo kufanele futhi nendlela ke esikhuluma ngayo noma ke amazwi ethu noma ke itone yevoice ke sibheke ke ngoba nayo ke isingenza ke ukuthi noma umbuzo lona ubuzileke kodwa indlela okhuluma ngayo noma ke iphimbo lakho noma ivoice yakho ingakhona ke isingashintsha ke lokho obuthi wena ukuhlose ukukubuza noma uhlose ukuthi ukuzwe ngoba indlela okhuluma ngayo kusengenzeka ukuthi akusiyona indlela ekuyiyona noma efanelekile. Futhi ke nenhloso ukuthi ke uma ngabe ubuza noma uhloma imibuzo inhloso ukuthi ke uthole iqiniso. Yase iphawula ke nangalo icala lakhe uState versus ucele la ngo1965 ilona ke icala elihamba phambili mayelana nendlela ekufanele ukuthi imibuzo ihlonywe ngayo einkantolo zethu. Kufanele futhi ukuthi ke kubhekwe ke nendlela ke ekuhlonywa noma ekubuzwa ngayo imibuzo nendlela ke nenkantolo yasho ke futhi nala kunommangalelwa khona ke asithi uyena noma umsolwa obuzwa imibuzo ikakhulukazi ummangalelwa ongenaye ummeli. Inkantolo ifanele ibheke nalapho ke ukuthi asithi umshushisi ke obuza loyo mmangalelwa imibuzo nangendlela ambuza ngayo ukuthi inkantolo kufanele ukuthi naleyo ummangalelwa imvikele. Inhloso yokuhloma imibuzo akusiyona ke ukuthi uducilele phansi isithunzi somuntu nokuthi futhi sekuze kufinyelele kwelazinga ekufinyelele kulona ke izolo la sekubonakala ukuthi khona ke amazwi asekhishwa ke manje akusona ke afanelekile nokuthi okunye futhi kufanele nokuthi kugcinwe ke isithunzi sakhe ufakazi. Umuntu unelungelo lokuthi ke abizwe ke ngesikhundla leso sakhe noma mhlambe kuthiwe mnumzana ke ukuba umuntu wesilisa nanjengoba kusho umthetho. Kungako ke kufanele isithunzi sikafakazi naso ke singadicilelwa phansi. Wonke umuntu unelungelo lokuthi ke abizwe nangesibongo sakhe uba mhlambe ke engabizwa ke ngesikhundla leso anaso. Akusiyona into eyamukelekile ukuthi umuntu ikakhulukazi umuntu osekhulile abizwe ngegama lakhe, kodwa ke kufanele ukuthi kusetshenziswe isibongo noma ke kusetshenziswe isikhundla leso. Kanye futhi ke naye ke umshushisi ikakhulukazi la bese sishilo ngaphambilini ummangalelwa engenammeli khona ke naye indlela abuza ngayo noma ahloma ngayo imibuzo kufakazi inkantolo kufanele naloko ikubheke. Kufanele futhi nala iqiniso nalo ke lowo obuza imibuzo angayiqi imizila ke yokufinyelela noma yokwazi iqiniso. Kufanele naye kube umuntu oneqiniso ke ngaphambi kwayo inkantolo nokuthi ke kubuzwe imibuzo kuhlonywa imibuzwe kuthatha isikhathi eside. Inkantolo naloko kufanele ikubheke ukuthi imibuzo ingenziwa ukuthi kube imibuzo emide, kodwa ke kufanele kwazeke ukuthi ke uyakuphi ke loyo obuza imibuzo. Noma ohlezi ngaphambili inkosi yenkantolo uma icala lilethwa ngaphambi kwakhe yena ke akazi lutho abaziyo ke abameli kanye ke nabashushisi. Manje ke inkosi yenkantolo yona ke isilalela ke lokho okuthulwayo ngaphambi kwayo ukuthi ke icala lelo lingani. Akufanele ukuthi uma kubuza imibuzo kungabi namizila ke noma kungaziwa ke ukuthi loyo obuza imibuzo uhloseni noma uya kuphi, kodwa kudedele nje kuvunyelwe ukuthi imibuzo ayihlonywe noma kukanjani. Futhi ke ukuhlonywa kwemibuzo akusiyona ke inhloso yako ukuthi ke kubhekwe amandla noma ke kubhekwe istamina noma umfutho womuntu ukuthi ke ngenhloso yokuthi ke akhathale ummangalelwa noma ufakazi loyo ohlonywa imibuzo. Inkantolo isingangenelela ke kodwa ke hayi ukuthi manje kube yiyona ke esithatha indawo yaloyo obuza imibuzo, kodwa la ithola khona ke ukuthi cha manje ke useyeqisa ke loyo ngendlela ke ahloma ngayo imibuzo. Futhi ke washo ke nokuthi ke kwakuyona ke lencwadi le inkantolo eyifundayo ke ngomthetho ukuthi inkantolo kufanele ukuthi yona ke isabise ummangalelwa noma ufakazi ngendlela imibuzo ehlonywa ngakhona. Futhi ke akufanele futhi ukuthi inkosi enkantolo noma ke umehluleli angeneleleke la khona ke kunemibuzo ukuthi ke aphikisane ke into ende nabeshushisi abameli noma ke ummangalelwa ukuzama ke ukuthi uphazamisa ke indlela bona ke ababeka ngayo icala labo ngaphambi kwenkantolo futhi ke inkantolo la afunde khona ushilo ke nokuthi ke ayivumelekile ke ukuthi nayo ke ukuthi ke ihlome nje imibuzo nakuphi na ufakazi wase show ke icala ke lakhe ujudge Siriti yena ke owanqaba ke ukuthi la umbuso wafaka isicelo khona ke ukuthi babizise ufakazi ukuthi ke azochaza izinto ezithize nanjengoba nalona ufakazi ke ebiziwe emuva kokuthi bese eqedileke ukuthula ubufakazi bakhe lapho kwatholakala khona ke uma lelo cala selindluliselwa ke eBloemfontein eSCA ukuthi ke cha umehluleli lapho wenza iphutha ke ngokunqaba ukuthi loyo fakazi loyo abizwe azochaza lokho ebekufanele ukuthi akuchaze phambi kwenkantolo ila khona ke gcineni umehluleli seshilo ukuthi inkantolo nje ikhathazekile indlela ke ekwenzeke ngayo la enkantolo izolo kufanele ukuthi ke sonke uma sihlezi lana ke umuntu ngamunye ahloniphe omunye ngoba sonke egcineni into esize ngayo lana iyodwa size ukuthi ke sizothola iqiniso mayelana lokho okwenzeka. Thank you, my lord.
Yeah, okay. Yes, Mr. Badoy.
Advocate Mnisi is busy with
Oh, yes,
cross-examination of the witness.
Okay, yes, you can continue, sir.
Certainly not so sure whether if I raise my voice to the verification that I'm badgering the witness so once. But I think I mentioned yesterday to the witness that when I raise my voice, I'm really trying to understand me and hear what I'm asking you. So, but nonetheless, I'm going to proceed. And furthermore, my lord, let me just put it on record that I could discern no sense of acrimony between myself and Colonel Smith, and I'm sorry, and Colonel Stay. Let's even proceed, sir. We were busy with page 23 of Exhibit 01, your table. You were trying to make amends to that table, that little table that you prepared today, after you indicated to the court that you should have effected those amendments. And indeed, we had gone some stages in making those amendments. Do you still remember?
That's correct, my lord.
Thank you.
Yebo ngiyakhumbula ke ukuthi ke besisakhuluma ke mayelana noshintsho ke lo bengishilo ukuthi bekufanele ukuthi lenziwa ke kuyona ke le document le ephambi kwami ngasho ke nala bekufanele ukuthi sishintsha khona.
Now, you would recall that we had made amendments. Actually, you had made amendments in respect of that column that's state start date. You had amended the times that are reflected in that column in both lines, so in both transactions. Not so.
That's correct, my lord.
Thank you.
Bese ngishilo ke nala qala khona ke idate ila engishilo ukuthi kufanele kushintshweni kube yini.
Now, you further said that there should also be a change on the towers, which are reflected in this column as cell names. Is that correct?
That's correct.
Thank you.
Ushilo ke ukuthi kufanele futhi namathawa ke ashintshe yebo.
Is it further correct that whilst you're trying to do that, you could not, you started off by trying to find the necessary document that would assist you to effect the necessary changes of the tower in the first column? You could not find that document. In fact, you said that that document contains wrong information. It's not the right document that you had there. You went to a second document which was not written. In other words, it was blank, something that you took up with the state. That's when then I interfered and said, you don't talk to the state when I'm cross-examining you, you're talking to me. And then thirdly, you said, no, actually you can't, you're not in a position to state what change must be effected in the third column because there was a movement. Do you still remember that?
That's correct, man.
Ngiyakhumbula ngisho ke ukuthi ke kule yesithathu ke icolumn noma umuntu akangikhumbuli ke noma ngazi ukuthi yini ke kufanele ishintshe ngoba ke kwakhona ke ukunyakaza noma ukuhamba hamba kwakukhona lapho.
Okay, my lord, I just want to explain. I first want to apologize to losing my temper yesterday in your court. I was tired and irritated, but thank you.
No, no, fine.
Ngiyafisa nje ukuthi ngikusho ke lokho ukuthi okoqala nje angixoliseke ukuthi ke kuye ngiye ngaba ngale yandlela ke izolo bengikhatheleke ingakho ke kuye kwaba ngale yandlela.
After yesterday, after we went home, I searched for a right paper because this one wasn't in the bundle of Pinky Exhibit Triple J. So I found the correct one, so I'm able to give the correct tower to the court now. It still doesn't change anything. It still, she was on her way from Kimberley back to Joburg. So it's just the position of the towers which come in question. It's not applicable actually. It's just showing that she was moving. The fact of the matter is there was communication between the two numbers.
Izolo ke ngathi ke bengifuna ke lamaphepha ke lana leli belingekho ke kuhla kulamaphepha akhe ke uPinki kodwa uma sengiya ekhaya ke ngalibheka ngalithola akukho ke okushintshayo ke kusaveza ke nalapho ukuthi nje amathawa ke ukuthi nje wayesendleleni ebuya eKimberley eza khona ke ngala eGoli futhi ke akushintshi ke ukuthi ke kwakhona ke uqhumana phakathi kwale number ezimbili.
If the court's allowed, I just want to hand in this page as Exhibit Triple K5C.
Okay.
Defense doesn't have in the court.
Let the defense first see the document first. Yeah. Oh, yeah. Did you? Yeah, even I don't know if you
Yes.
show the prosecution. I don't know if they saw
Is that
it.
all?
It's only one page.
Only one page. Lord, it's only from the beginning to the end now, so now it's a complete from the start moving in Kimberley.
So that will be exhibit what, Mr. Baloi?
KK5C.
KK?
Triple K,
Hmm.
5C.
5C. You'll have to make copies for the defense, okay?
I did make extra.
Oh, you did make?
Yes.
Oh, okay, fine.
I'm going to request for an adjournment, my lord, for
Okay.
me to go through this document.
Okay. What's the time now?
11:20.
11:20. Okay, we'll come back after 15 minutes. Is it okay? Yeah. I don't have a copy of triple K4.
5C.
5,
5C.
yeah, 5C, where is it? I don't have a copy.
I did. All the copies I handed over that side.
Yours, where's mine?
I handed the whole.
Okay, fine, fine. At
Okay,
least
so then-
don't just forget. Okay, you can keep it. Okay. Oh, Mr. Sibanda has got a copy also. Okay. All right, thanks.
As
Yeah.
it please the court, my lord, and thank you very much for the indulgence.
Yes, sir.
Mr. Colonel Stein. Now, yesterday, you're telling the court that in terms of the tower in column 1, that there should have been a change. Not so.
Column?
In the first line, one page 23, in terms of the tower in column 1, the first line.
Yeah, no,
Now,
first one.
yesterday you told the court that there should have been a change, not so.
That's correct.
Yebo ngishilo ukuthi kuleya tower le ebhaliwe ke ukuthi Kimberley bekufanele ukuthi ke ishintshwe.
Now, today you are saying there should not be a change.
No, I didn't say that.
What do you say?
I said that one still have to change.
Ngiyasho ke noma ngisasho ke namanje ukuthi leyana kufanele ukuthi ishintshe.
No, thank you.
That-
Then
that-
it changes to what?
That's why I handed this exhibit triple K5 to the court now.
It
Ingako
changes to
ke
what?
ngidlulisele-
You want to effect the change.
Come again?
You're saying that there should be a change as well.
That's
now
correct.
I'm saying to you, I'm asking you, it changes to what?
I can tell you now, if you go to your page triple K5C, the 10th, from the, you can take it from line number 9 from the top to around about 13 to the bottom. It will change to 3rd August 2014, 003541 until 004711.
Lana ke iqala ukushintsha ke nanjengoba besishilo ukuthi kubhalwe 2 lana August manje yashintsha ke to 3 August 2014 isikhathi u004711.
Then you can change the tower to 2G Doringpan MTN CEN. Yeah.
Okay, iyashintsha ke manje nayo ke i-tower kuba u2G Doringpan MTN CEN.
Or to 3G Wolmerans extension 10 CEN.
Noma ke uthi 3G Wolmerans extension 10 CEN.
Therefore, I still stand with my point, which I mentioned yesterday as well. She was moving on the way from Kimberley to Joburg.
Ngakho ke ngisamile ke kuloko engikushilo izolo ke ukuthi ke wayebuya khona ke eKimberley eza ngaseGoli.
Who was moving? Who was moving?
Who was moving?
The cell phone.
Wona ke umakhala ekhukhwini.
Thank you. Which cell phone was moving?
The cell phone moving.
Yes.
It's 2782 704 4358.
Lo makhala ekhukhwini ngikhuluma ngawo ukuthi wona ke owawumuva ke ukusuka ebuya eKimberley ukuza eGoli u278270444358.
That is the cell phone that allegedly received this call from the number ending 202.
That's correct.
Lo makhala ekhukhwini lowo ke wona ke wathola ucingo olubuya kule number egcina ngo202.
Thank you. Now, in Exhibit O of your affidavit, where do we get that information? That this cell phone ending with 4358 was moving when you received the the call from the number ending 202 at this time 004021 on the 3rd of August in your affidavit. Where do we get that?
That's not in that statement on my exhibit O. That's why I'm being recalled to explain to the court where it's coming from. And I already mentioned in my previous statement that I combined the two as a working document. That's why I'm here to explain to the court.
Lokho ke noma lokho engikushoyo ke ukuthi ke le colleague iyo noma le igcina ngo202 yafonela enye lena ke akukho lapha ku exhibit O, ingakho ke ngibuyile ke la enkantolo ukuthi ngizochaza kona lokho.
In your previous testimony, did you mention that?
I did mention it.
Kubufakazi bami bangaphambilini ke ngakusho lokho.
I also mentioned that I also worked on the section 205 as well as on the downloads.
Ngakusho nokuthi ke ngasebenza ngayo i205 kanye nayo ke i-download.
Did you mention in your previous testimony that this number ending with 358 received a call from the number ending 202 when it was around the cell phone tower at Warrenpan or Volmarans at the time of 00.40.47? Is that what you said?
That's correct, my lord. I didn't. What I also mentioned to the court, we didn't add in that stage the plus 2 hour rule. That's why we rectified it in my new statement.
Ngikushilo ke lokho kubufakazi bami bangaphambilini ke kodwa ke nanjengoba bebesingakhulumanga ke noma lingakushongo lokho kwamahora amabili ke ingakho ke manje ke lokho ngikulungisayo ke kwi statement sami.
So that's a rectification.
That's one of the. That's not a rectification. I just come and put it clear to the court that it was not with the 2 hour rule, but it still doesn't matter. The fact of the matter is there was transaction between the two numbers.
Lapho ke lokho ke ngokushoyo ke mina ke ukuthi ke ongashiwonga noma engakushongo nje yiloko amahora amabili ke kodwa ke akuwenzi umehluko ke okumileke ukuthi ke kwakukhona ke ukuxhumana okwakukhona.
Thank you. Now, with respect of the second column, you say the only rectification or clarification or correction that should be effected there is on the start date column. The time there should read 1933:57, not so.
That's correct.
Lana ke kumugqa wesibili ke ngishilo ke ukuthi okumele kushintshe khona ke isikhathi esibhaliwe u1733:57 kumele sishintshe ke sibe u1933:57.
Now, is that the only amendment or
That's correct.
correction that should be done in there?
That's correct.
Thank you.
Ikona kodwa ke kufanele kushintshe ke lapha yana.
Now, in terms of your recalling of your evidence overnight, in terms of the document which has just been presented now as Exhibit KK5C, where do I get the information that states that on the 3rd of August 2014 at 00:47, I mean at 00:47 at the tower Volmarans Doornpoort, the call ending with the number 358 received, the cell phone with the number ending 358 received a call from a number ending 202.
You're not going to get it on that page. You must go to your download. Then you will see exactly the time the same time as this one, and then you compile a working document for you, then you will find the same time, and then you will establish where the phone was and what call was made.
Lana ke ku triple K5C engiqeda ukumdlulisa ke kubameli kanye ke nabeshushisi nasenkantolo angeke ke ukutholeke la ekushoyo khona ke ukuthi kwakunocingo noma kwakunokuxhumana ke kulama number amabili u358 kanye naye ke u202 kuzofanele uye kubona ke kuyona ke i-download bese usebenzisa ke nale ababiza ngokuthi ke le abasebenza ngalo noma ke i-working document ila ozobona khona ke isikhathi kanye naloko kuxhumana nokuthi umakhalekhukhwini lo wawukuphi nendawo.
So the document that you presented here, being triple K5C, it's useless.
It's not useless. It gives the court an indication of the tower reception. Remember, on the download, it's only mentioned the time and the communication between the two numbers.
Ku download ke ila ezokunikeza khona ke isikhathi ke nokuxhumana ke kodwa lena u-triple K5C akusho ukuthi ke akukho okwayo ila ekutshela khona ke noma etshengisa khona ke inkantolo mayela namathawa.
I can mention triple K5C is a product from Vodacom, and the other one is a product from the police, a download.
Lena ke u-triple K5C yona ke ebuya ku Vodacom bese kuthi ke ama-download yona ke abuya emaphoyiseni.
In terms of the second column, you say the time is the only amendment that should be effected today.
That's correct.
Thank you.
Ngishilo ke kulona lesibili ke ukuthi ke okushintshwayo kuphela ke lapha isikhathi.
Now, is it correct that yesterday you told the court that in terms of the second call on Vittlingham's statement, because of the fact that it was made via normal airtime, there is no addition of the 2-hour rule, such that that information should just be kept as is, it remains as is. Is that what you said?
No, I didn't mention that.
You didn't do that?
No, I didn't.
You didn't say that?
No. I acted the whole time and said the 2-hour rule is inapplicable.
Angikaze ngisho ke ukuthi kulena ke document yakhe ku Vitlingham ngoba kwasetshenziswa ke nje i-airtime ejwayelekile ukuthi ke kufanele lapho ke amahora amabili angafakwa. Ngade ngisho isikhathi sonke ukuthi nje amahora kufanele ukuthi afakwe amabili.
My Lord, that has been I pick up that I haven't got the correct page. That's why I go back last night and found the correct page.
Ila engithole khona ke ukuthi ke iphepha ke noma ke ipage ebenginayo kumina ke akusiyona ke ekuyona kufanele ngisebenzise ingakho ke ngithe uma sengibuyela ke ekhaya ke izolo ke ngayobheka ke ipage ekuyiyona.
My Lord, I think in my notes I have it that I have it as I put it to the witness here. So the court indicated earlier on when the court was going through the authorities there is that we shouldn't really put an allegation to the witness which is not what he might have said. So I'm going to request indulgence from court just to verify this allegation. Otherwise, if it is not as is, I'm going to withdraw it.
You're going to?
I'm not. I am going to withdraw it, my lord.
Withdraw what?
Withdraw what I've put to this witness. But up until now, I think this is. I have it like that in my note, and before I withdraw it or I make amendments to my note, I just want to verify this allegation that I put to him. I'm therefore going to request for an adjournment, my lord, because if it is, he said what I've put to him, that I'm going to further explore this point.
My Lord, I don't see where is the difference now.
I'm
Because
requesting an indulgence from the court, man.
Yeah,
I-
okay, let's hear what.
I can rectify. If I said something wrong yesterday, I rectified myself today. I got it on paper. I handed in exhibits, everything now. So I can't see what is wrong now.
Uma kuukuthi ke izolo ke khona ke ngikushilo engasikona namuhla ke ngikulungiseleke futhi ngase ngiza ke nale page ke manje ke angiboni ke ukuthi inkinga ekuphi.
So you want us to play back the tape? Or what do you want us to do, sir?
I'm going to verify with my colleagues here, my lord, if they captured the same information that I've captured. If it needs to be, indeed, we're going
Yeah,
to
let's repeat
request.
the information you say you have captured.
Excuse me, my lord.
Repeat the information you say you have captured. I've written it down, but repeat it
Thank you.
so that we all capture it.
Yes.
You said, he said,
According to how I understood him,
yeah, he said,
he said the second call on Vittlingham's statement, which is a call that was made on the 15th of October 2014. It is a call that was made via normal airtime. And there was therefore no need for the addition of the 2-hour grace.
scientifically, that
I did mention that, my lord, there was no need to change. Remember, already we changed the time, but the tower is the same. So there's no need for changes in the cell names. She was still in the same vicinity.
Lana ke akushoyo umeli athi ke ufakazi ukufile ukuthi ke kwicall yesibili ke yayo yakhe ke uVittlingam sasingekho ke isidingo sokuthi ke kushintshwe ke lamahora amabili ke ufakazi uthi yebo ngishilo ke bengikushilo ke lokho ukuthi azange sibe khona ke isidingo sokuthi ke kushintshwe ke ngoba ke wayesekuyona ke indawo eyodwa.
so are you with the witness, Mr. Mnisi?
No, I'm not with him, my lord. I am on
Let
my
me
own.
say, the way I understand you, sir, the determinant of adding the 2 hours is not predicated on the situation of the tower.
That's correct, my lord. She was still, for 2 hours or 3 hours, she
Same
was in the
vicinity.
same vicinity.
That's how I understand him.
Yeah.
Masokhuluma isilungu.
Amahora amabili ke noma amathathu ke wayesese endaweni eyodwa.
So in other words, if he had if he had moved
Then it
to
was
the next tower,
That's
which is
what-
different from the one initially which he traversed,
That's correct.
then you change it.
Then it should change.
But if it is the same tower,
That's correct.
there's no need to change.
No need.
I mean,
Uma bekuwukuthi ke ube usukile ke wase eya kwelinye ke la bekuzoba noshintsho khona ke kodwa ngoba ke akayanga ndawo ke nama bese kuleya ndawo ke ingakho ushintsho lungekho.
so you can check that explanation of Ms. Colonel Stein. And then
No,
you can
but-
argue about it that he was wrong, and you can quote it like your learned colleague, they were saying page 11, line 20, what, to save time.
My lord, I don't want his explanation.
Oh, I
Remember,
see.
I am
Okay,
the-
let's agenda. You want us to agenda for how long?
I'm requesting for an intelligence to check on this.
Yeah, how long? How long?
I think as soon as we're done, we'll let the court know through the
There?
court register.
We don't want to do it now. I can agenda. And come back after lunch, 2 o'clock.
That is what I'm saying, my lord, that as soon as we're done, it could be 15 minutes, 30 minutes, but as soon as we're done, we'll let the court know through the court
No,
register.
why don't you do it now? Because now we are aware of this. You check it with your colleagues, and then you get there's the record there. You get the page on the record. You will say it is on page this. You read
Yes.
it on the record, so that Mr. Colonel Stein can react. Okay. So
That
how
is
long
what
do you
I'm
need?
saying, my lord.
Hello.
That is exactly what I'm saying.
Yeah, that's how long do you need? 10 minutes, 15 minutes, an hour, what? And then you can call me. I'll be in my chambers.
Which is the reason why, my lord, I'm saying that as soon as we are done, we'll
Done with
let
what?
the court know through the register, verifying that information.
So how long should I do?
Let's give it 30 minutes, my lord.
30 minutes, is that okay?
It might even be lesser than that,
Yeah, you'll call me when you're done.
as it is the court.
we just thought that we'll first find a place and then play it in open court so that the witness can also hear it.
Also, you want to play it in open court?
Yes, yes.
Okay, they say that you guys agreed that it should be played in open court.
I'm grateful
But
if that comes
will we
from
hear
the
that?
statement.
Because
Yes.
that microphone, yeah.
We've got a speaker, my lord, that
Yeah.
was able to increase the volume.
Yeah, fine, okay.
Thank you.
The second call, yeah. The call has been made. This one has been made via the towers, normal airtime.
Sorry, when you say, is it the internet operating?
No, it's a normal
The normal,
way of calling.
okay.
Yeah.
So it's not data?
It's not
It's
data.
not data, okay.
It's as I say, this airtime
Yeah,
you pay
fine.
for it.
Okay.
Yeah. It's the time is 2240 and the second call is 1753:57. Sorry, okay. The time is 1753:57
Starting of 17:33:57.
and the duration is 998 seconds. Yeah. This one must differ from the download because on your download you got to 2 hours plus 2 hours and the cell phone data from Vodacom or any service provider is real time.
Thank you. Thank you, my lord. I'm indebted to the court. However, I just need to correct one thing from the submission. From the assertion that I put to the witness. I said to the witness that he said the second call on Vitlingam's statement. No, that he didn't say. I think that's where I made a mistake. Yes. He was basically referring to his own statement.
Saying what?
As it is the court, my lord.
Sorry, Colonel, did you listen and hear what this is all about?
Yes, I listen and I still stand with my point. I mentioned plus 2 hours. I can't see where is the difference.
Ngikulalele lokho okuqeqeshelwayo ke manje lana ngisasho ke ukuthi ke amahora amabili angikatholi ke ukuthi umehluko ukuphi nendawo.
Yes, sir.
Thank you. Now, just to let the court understand, I'll try my level best to understand what this is all about. The witness said when a call is made using a data, that is where the 2-hour grace is applicable. In other words, on that call, that's where you add the data. That is where you add the 2 hours. As it is happening in the first call, that is on the 12th of August 2014 at 22:47. According to him, because this call was made via the usage of a data, that is where you then include the 2-hour grace.
So it's not a question about whether a call was made or not, as I understand you.
May I finish what I'm just
Okay,
started?
fine, fine.
Thank you. Now, this witness says, when a call is made from a normal airtime, you go to the shop, you buy airtime, and you're not using data, then the record that you're receiving from the service provider, the time thereon does not change. In other words, you do not add that 2-hour grace. If it says 17 hours, if the call was received or made at 17 hours, 33 minutes and 57 seconds, it will remain like that.
Is that what he's saying?
That is what he said.
So you want to put it to him, that is what he said? You say
That was his explanation. Is that not what you explained, sir?
No, my sir. No, my lord.
Yes.
It seems to me, I already phoned my wife that I must relocate it
You
back
must?
to relocate it back to Joburg because it's going to take long to explain to him how it's working.
Yeah.
Because
No, now he's being sarcastic, my lord. And the
No,
court
that's
has
my
just
point.
indicated to him in the morning that he will have to avoid to be sarcastic. I don't understand where the wife gets in and his relocation from Joburg comes in.
Yeah,
in the
that's-
context of the question
that's
that I'm
uncalled
trying
for.
to ask. Because I'm also capable of doing that.
Okay, let's set progress. You heard what
I heard what he
Advocate Nisi says?
yes, yeah.
Is that what you said?
It's what I said.
But
he mustn't just take it until a point. He must
Right.
take it further. If you're working on a download, it's +2.
Yeah.
If it's Vodacom, like I said, airtime, real time, it's real time. So the moment you're working on a download, it's a +2. If it's normal time from the Section 205 records, it's real time.
so it has got nothing to do with airtime.
Nothing, nothing. And even if you got data which you paid from, and it's coming from the Section 205 records, it's real time.
Ngiyakuzwa ke lokho akushoyo ke ummeli ukuthi ke yilokho ezekushilo kodwa ke kufanele ke lokho aqhubeke
Okay,
ngakho
you can go,
ukuthi
Mr. Nisi.
Sir, was it not you who've just heard yourself from the record saying that this is real time? The time which is reflected there on call number 2 is real time because that call was made from airtime.
If you listen further on, I did mention 1733. Then on my last sentences, I mentioned +2 hour roll.
Let's listen further. Let's listen further.
My lord, I just want to see because I've seen now on this second page we found the wrong one.
It's not complete.
Which page are you
It's
referring
not
to? Second
completed.
page before?
Where you were responding, it's not completed.
Okay, fine. Even on this one here, we printed the wrong page here.
So, okay, just for me to understand further, what has this 2 hours got to do with the birth of Christ? Because
Thank you.
I thought
Thank
the
you,
real
Madam.
gravamen of this exercise, it's about whether accused number 5 communicated with Kelly at a certain time in October and again in August. I don't know. The fact that the time is 2 a.m., does it affect the call itself? If there were calls made, I don't know.
Yeah.
Does it affect the calls?
Nothing.
2 hours, or whether airtime, or whether data,
Yeah.
does it affect the communication?
Nothing. You have to call us.
Nothing turns on it.
Nothing.
ngomdaba ke lamahora amabili
No, you can go
ukuthi
on.
kwakuyi-airtime kwakuyi-data ke lokho akushintshi ukuthi ke ukukhulumisana noma ukuxhumana kona kwakukhona
My lord, I don't know whether the court wants to find that from me or from the witness.
No. I was asking the witness.
Oh, okay.
You can go on with your cross-examination. That was from my own understanding.
That whether it was a 2-hour thing, it really does not mean anything.
According to him,
Yes.
it doesn't affect the communication time.
Thank you, my lord.
That's what he says. Don't say I say that.
Thank you, my lord.
Okay.
No. It doesn't affect the time.
No, the
the
call-
fact that the call has been made.
That's it, the time
Yes, yeah.
when the call is made.
Yes, there
That's
was a call. Doesn't matter if it's 2 hours earlier or later.
That's it, yeah, that's,
ukuthi-ke kwakungamahora amabili ngaphambili noma ngasemuva-ke kona-ke akukushintshi lokho ukuthi kwakukhona ukuxhumana kwakukhona.
okay.
Thank you, sir. Now, in terms of that table, the second line, you are saying, you have been heard saying that because this was a call that was made via normal airtime, the time of the making of the call does not change, not so?
No, I didn't say that.
Angishongo-ke ukuthi-ke lesi sikhathi lesi-ke la esibhaliwe la u-1733 ukuthi asishintshe.
From what we have listened now, what
My
did
Lord,
you say?
if I remember correctly, yesterday you mentioned to us that we must start talking about 20 to 1 or 10 or something, and then also, I even write it down here somewhere. So that you can't just use parts of my testimony, you must listen to the whole story. In that one, I already mentioned, you must take in mind the section 205, the 2-hour rule. So I don't know what is the discrepancies.
Bengishilo-ke lana-ke noma uma ulalela laphayana ukuthi-ke kufanele-ke uma kuyi-205 leyana-ke ukhumbuleke ukuthi kunalamahora amabili-ke engikhulume ngawo. Na izolo-ke inkosi enkantolo ishilo-ke ukuthi mhlampe uma sibiza isikhathi-ke sifanele sisibize kanjani ukuthi ufakazi kukhona-ke la abekubhale khona lokho.
So you still stand by your testimony that on the 15th of October 2014 at 19:33:57, there was a call that was made from the number ending 202 that was received by the number ending 358.
Come again with the numbers?
I am saying, you are then saying that on the 15th of October 2014, at 19:33:57, there was a call that was made by the number ending 202 that was received by the number ending 358, which call lasted for 98 minutes.
That's correct.
Usasho yini-ke ukuthi ngazo i-15 ka-October 2014 ngo-1933:57 kunelela cingako olabuya ku-202 liya-ke ku-358 uthi yebo kuyiqiniso.
And that's the information that you got.
Simnis-
Oh, sorry.
It's not 98 minutes, 98
Yeah.
seconds.
98 seconds, yes, I'm sorry. And that's the information that you received from downloads.
That's correct.
Information ke leyo engayithola kuwona-ke ama-downloads.
So, in other words, this number ending 202, when it called the number ending 358, the duration of the call lasted for 98 seconds.
That's correct.
Nokuthi-ke lolo cingo lolo-ke buya ku-202 luya ku-358 kwakungama-seconds noma-ke imizuzwana ewu-98.
And it was an incoming call in respect of the number 358.
That's correct. If you go to the downloads of the cell phone, you will pick it up.
Yebo uma uya kuwona-ke ama-downloads ama-cellphone ila ozothola khona-ke ukuthi ucingo olalungena kule number ewu-358.
Who prepared those downloads, sir?
It's been done by the downloader. He is using the XRY program.
Ama-downloads lana enziwa-ke uyena-ke umuntu okwenzayo lokho ukudownloada osebenzisa-ke uhlelo noma-ke iprogram ebizwa ngokuthi XRY.
Do you have an idea who that downloader is?
It's Sergeant Muswana.
Usergeant Mushwana lowo.
Thank you. So you are saying what we just heard on the speaker here, on the record here, is not what you would have said yesterday.
It's exactly what I said, but I said you can't just listen to parts of my speech, of my testimony. You must take the whole testimony in consideration. It's easy to just take one page and say this is what the law says, or what I explained to. Listen to my whole testimony.
Angisho ke ukuthi lokho oqeda ulalela laphayana akusona engikushilo kodwa ke ungalaleli ke indawo ethi ufice endaweni ethize kodwa ulalele kona konke engikushilo.
Just bring me out. Now I'm going to take you to an extraction, to an extract of what you told this court when you testified on the 27th of July 2023. And that information you're getting it from, I'm going to read from page 75. I'm going to go to page 76, and I'm going to go up to page 77. Now, it's a record dated 27/07/2023. Now, I'm going to start at line number 6.
It's in which page now? Come again.
I've said page 75. That is when you were being led by the state, Mr. Baloyi. Now it says, Mr. Stein. Oh, let us start there at the very beginning, on top of the page, where it says, Mr. Baloyi, that's now the prosecutor is speaking to you. He says, yes. Then on page 21, it goes on with all the calls being forwarded on 21, and it runs over to 22. Also, all calls forward until page 23 and 24. And then you proceed and say, page 23. Then my next point during my analysis, I discovered that Kelly Kumalo with the number 278270444358 received a call from Ntulinkani with the number 277-3305-9202. Then the state says to you, can you just read that first name? And you are saying it is Sifoguhle. The state says to you, Sifoguhle. You have written in brackets 5. What does that entail? Mr. Stein says, it means suspect 5 in front of the court. Mr. Baloyi, how did you establish this number of which is 5? Mr. Stein, like I mentioned in the beginning, I drew up profiles of all the targets as well as the suspects through all the systems which was to my disposal, which I was using. So on that, I did identify the number belongs to him. The next spreadsheet I took out. Then the court intervenes. Sorry. For my edification, what time was the call? Mr. Stein, I will come to that, my lord. The court says, okay, no problem. Then on page 76, you are saying, my next spreadsheet is an extraction from there. This is the section 205 of the phone of Kelly Kumalo. The first I mentioned that the cell phone number, it is 278270444358. The next number we are going to read is the IMSI number. It is a SIM card number. The number is 655-0139-6061. The next one is an IMEI number, the handset number. The number is 35-150-305-303-538. And the call type is MTC. In other words, terminating call. She received the call. The start date of the call was 2 August 2014, and the time was 22:40:47, and the duration of the call was 110 seconds, close to 2 minutes. She received a call from the other party 277-3305-9. 202. Mr. Baloyi says, you say the other party is, and you say it is suspect number 5, Nkani. And she received the call while she was in the vicinity of the Tower 3G, Kimberley, MWCEN. Then the court says, we repeat, it is 3GK CF in Kimberley. K stands for Kimberley. Where about is that, Mr. Stein? It can be Kimberley, the court. Kimberley itself. Mr. Stein, yes, itself. The court. It is not that as a court. Okay, fine. Mr. Stein, if I read the other towers, is it possible that it is so? Court. Okay. Mr. Stein. Then the next entry on the spreadsheet, that is now on page 77. The next entry on the spreadsheet, it is also from the same cell phone number, the same IMSI number, the SIM card number, but the IMEI number, the handset number, it is different. So it is possible that she could have updated the phone, or she just used another handset. The handset number of this one is 863372 02137621. Then the call type is also an MTC, a terminating call. In other words, she received a call, and the call was on 15 October 2014 at 17:33:57. The time of the duration of the call was 98 seconds, a minute and a half more or less. Then the other party is the same. It is 077-33059-202, which belonged to suspect number 5. The tower reception area was 2G Ivydale Farm, somewhere in Limpopo. I did follow up. It is the court somewhere in yourself saying in Limpopo. Then the court says, oh, in Limpopo. And then you say yes. Mr. Stein, yes. Court, yes. Mr. Baloyi, yes. Yes. You may proceed. Okay, the next is also an extract out of the section 205 from the cell phone records of 2 August and 15 October. I'm going to stop there. Did you follow what I was reading?
That's correct, my lord.
Thank you. Mr. Stein.
Colonel Stein.
Oh, I'm sorry. I'm sorry, Colonel. I'm sorry. Yeah, Colonel Stein. I'll probably get used to the word Colonel. Yes, yeah. I'm used to mistake. But Colonel Stein. Now, you knew all along that you had downloads, not so. And the information that is contained in the downloads is different from the information, or it will give a different information from the one that you've just put on record here, not so?
No, I didn't know.
Bengazi-ke ukuthi-ke ukubona ama-downloads ukuthi-ke kuhlukile-ke kulokhu-ke okuqeda ukuthi-ke ukufunde khona la.
You did not know that you have got downloads, information from downloads.
I did mention to the court, I just forgot to put in the 2-hour rule.
Ngikushilo-ke enkantolo ukuthi ngakhohlwa nje ukuthi-ke mina-ke ngifake-ke lokho kwamahora amabili.
And I did mention in my previous statement on page 76 an extraction from the section 205.
Ngikushilo-ke futhi naku-statement sami-ke esingaphambilini-ke kuyona-ke upage 76 ukuthi-ke lokho okakhishwa-ke kuwona ama-section 205.
Thank you. Now, you forgot to include such a vital information, number one, in your affidavit. I've stated all the possibilities yesterday. I brought them to your attention, all the possibilities yesterday. The instances in which you could have included that 2-hour time. in them. But in all instances, you forgot, not so.
That's correct.
Thank you.
Yebo ke kona konke ke lokho okushoyo ukuthi ngibaleleke amahlandla amahlanu kodwa ke kona konke ke lokho ngakhohlwa.
Of importance is also the fact that when you testified, as per what I've already put on record and read from the transcribed record here, also you forgot that, oh, I've got this 2-hour grace thing that I also need to mention and talk about. You also forget that, not so?
I didn't say it is important because, like I just mentioned to the court, the fact of the matter is the call has been made. Doesn't matter if it's 1 day earlier or 1 day later. The call has been made.
Colonel Smith.
Akushongo ke ukuthi ke kuyinto ke esemqoka noma ebalulekile amahora amabili. Engikushoyo ukuthi ke kona lokho akushintshi lutho noma kungo usuku ongaphambili noma ongasemuva ke kodwa kusemqoka ukuthi nje i-call yenziwe.
Colonel Stein, I'm not asking you whether a call was made or not. I am saying to you, and please answer the asked. I am saying to you, when you gave your evidence, in respect of what I've just read out to you from the court record, you also forgot to say, no, there is also that 2-hour grace that I also need to add in the information that I'm now narrating to this court. You also forgot to do that, not so?
That time, no.
Ngaleso sikhathi yebo ke lokho kwamahora amabili yebo ngakhohlwa.
A very forgetful colonel. A very vital information. A colonel that has been requested to come and assist the court through all the process, from the drawing of your statement, your consultation with the state, your testimony here at court, cross-examination, you don't mention no nothing. You come yesterday, you say you forgot. That's a forgetful colonel.
I didn't mention it only yesterday.
Before the witness answers, we don't want to repeat yesterday's objection. We did refer to the relevant page that the witness did mention the 2-hour issue, and I think this cross-examination must keep that in mind.
Mshushu siyasho ke ukuthi ke akafunile ukuthi aphindaphinde ke bekushiwo ke izolo kodwa ke ushilo ke ipage izolo ukuthi ke ufakazi wakusho ke lo daba lolu lamahora amabili.
You know the reason why you forgot this, sir? And I'm going to be very frank and brutally honest with you. It is because the court said earlier on that we shouldn't really say that a person is lying. Unfortunately, it has been omitted to indicate to us that in an event that I want to use the word lie, what word must I use so that it sounds very, very polite? But nonetheless, I will not be using the word lie out of respect, decorum of this so respectable house. But what I'm going to put to you now is that you did not forget, number one. Number two, the information that you gave on record here, it is information that you came here prepared to come and deliver. There's nothing that you forgot here. Do you have any comment?
That's correct, my lord. I
Thank
first
you.
want the court to ask him to withdraw the word lying. He already painted me black in the media for lying, and even the court called me back to come and rectify the so-called shortcomings, and I'm not willing to take that again.
Ngizothi ke mina ke awukhohliwe ke lana ngongafuni ke ukusebenzisa ke igama elithi ke uqamamanga nanjengoba inkantolo ixwayisile ke uma ibisitshela ke ekseni kodwa ke ngizothi nje mina ke awukhohliwe kodwa ke ukuthi nje lokho ke okushilo ke lana ikona ke oyilungiselele kwana ukuthi uzofika ke ukusho la enkantolo Uma sephendula-ke ufakazi ngizocela-ke inkantolo iqale ngokuthi-ke imxwayiseke ukuthi-ke uqiseke leli gama elithi inqambamanga nakwinkundla-ke zokuxhumana-ke usengipendile-ke nanjengomuntu-ke onamanga futhi-ke ngize la ngoba inkantolo-ke ithe angizolungisa-ke la engingahlangani khona.
I'm here with section 205 printouts. I'm here with a download of the cell phone downloads. It's been handed in as an exhibit, so the proof is there.
Ngize lana-ke ngiwaphethe ama-section 205 ngize la ama-download ngiwaphethe-ke ubufakazi-ke bukhona kulapho.
Yeah, Mr. Mlisi. Normally, let's just be logical. Do you have any countervailing evidence that the kernel is incorrect? I'm not saying he's lying. Normally, if you putting an assertion to a witness, you tell the witness, I'm just giving an example. After listening to the witness, you tell him that, for instance, you know what, there's another expert. His name is Voter House, Colonel Voter House. On the same aspect, he maintains that you can't forget, for instance, the addition of 2 hours. And that 2 hours is critical. The colonel says it's neither here or there. But you're putting it to him that he's incorrect, but you don't put any countervailing assertion or evidence to contradict his own assertion. And of course, the court will have to make up his mind where the truth lies. But as far as this is concerned, we have one version. The only expediency around that version is that the colonel says he forgot. And according to the state, the colonel rectified that in a subsequent utterance. Just read that. It's in page what? You say it's there. I don't keep records like you guys every day. You say it's on page what?
The one that I read yesterday is page 69.
No, the one you say here, you corrected it. It's page what?
Page 69.
Page 69. On which day?
27 July 2023.
Okay, what did he say then? Because I don't have the record.
Well, he said, we must keep in mind if we are going to work on the cell phone downloads, with the downloads of the phone, you must always add plus 2 hours to the time which is being mentioned on the download. So if the download says it's 4 o'clock, then it's at least 6 o'clock.
Uyafunda-ke lana-ke mshushiso bekufundile-ke izolo la athi khona-ke upage 69 kulokho kwenzeka-ke noma-ke kubufakazi-ke bange-27 July kunyaka ondlule ukuthi-ke ufakazi wakusho-ke lokho ukuthi uzokhumbula-ke ukuthi uma usebenza ngama-downloads kunala khona-ke kusetshenziswa khona-ke amahora amabili uma kuwukuthi kuwu-4 noma kubhalwe 4 kusho ukuthi-ke u-6.
Yes, Mr.
Thank you, my lord. Let me quickly assist the court.
Yeah.
Accused persons are not here to prove anything
Hello?
against them.
No, I know the onus is on the state.
Yes. So I'm really
No.
flabbergasted for the court to mention that if you've got something countervailing to counter the evidence.
Yeah,
of the
because you
citizen,
say this
then we
with-
must bring
no, let's-
our own aspects.
No.
In other words, the court is saying that
No.
the
No.
accused
Aye.
now bear the honors of proving
Aye.
their
Never.
innocence beyond reasonable doubt.
Never
That's
said
not
that.
our function.
No. I'm not talking about the incidence of owners. I'm talking purposes of statements made.
Yes.
This witness, let's use your language, is lying when he says he forgot the 2 hour stipulation. Now I say there's nothing countervailing to that. It's different if you say the stipulation is 5 hours or the stipulation is 3 hours. But here, Mr. Baloyi reads an extract on the 27th of July, last year, is it?
Yes, indeed.
This witness does speak about the 2 hour I'm not saying that. It's the record which says that. Please. I'm not saying that.
Thank you, my lord. But another thing is, this witness says,
Yeah, fine.
I've said to him that he is lying. He probably misunderstood me. I said, because of the fact that the court in the morning said words such as lying should not be used, I am looking for a very euphemic term that I can use in order to demonstrate my assertion.
You are incorrect. It's one of them. I can give you 20 of those words. You are incorrect.
Thank you, my lord.
You are missing the point.
Thank you, my lord.
You want another one? I can go on and on and on.
That was only 2 out of 20, my lord.
Yeah, you want
Yes.
20? I can give
Yes.
you. You are mistaken.
Thank you,
You
my
want
lord.
me to go on?
Thank you, my lord.
Okay,
Thank you.
right.
Now, Colonel Stay, I'm putting it to you that this did not happen because you forgot. This happened because you wanted to formulate, conjure, fabricate, come up with non-existent evidence to falsely implicate accused number 5, to look as if accused number 5 on this day did have a conversation with the number that ends with 4358. Don't know who that number belongs to, but it is alleged that it belongs to Kelly Kumalo.
My lord, that is totally not true. The only mistake in here is the tower reception, which I put wrong in my statement because of the 2-hour rule. But the fact of the matter, there was communication between that two numbers.
Kona-ke akusona-ke iqiniso lokho akushoyo-ke ummeli ukuthi-ke mina-ke lana akusiyo ukuthi ngenze iphutha noma-ke asiyo ukuthi ngikhohliwe, kodwa nje ukuthi-ke bengizokhuluma nje into noma ngisho-ke into engasiyona ngaye ummangalelo wesihlanu ukuthi-ke ngempela-ke waxhumana-ke nayo le number lena-ke egcina ngayo 358. Iphutha nje ngalenza-ke lana ukuthi-ke ngenze iphutha ngayo ithawa ngoba ke ngingazange ngifake ke loya mthetho noma leya rule ke yamahora amabili.
That is my point. The fact that you are admitting that you made a mistake, it is because of that fabrication that I'm referring to. That at all costs, you wanted to formulate an information and bring to the attention of this court that indeed accused number 5 and the number ending 4358 did have a communication on this day. The reason why I'm saying that, and I want to be very sincere with you, it's because the information that you've brought to court here differs materially from what Ms. Vittingham can testify about. Do you have any comment?
That's correct, my lord. I
Thank
didn't
you.
fabricate anything. I only want to show to the court where number 4358 was going to receive the call. If I did have more information, like said, the cell phone download of accused number 5 and his 205, I could have mentioned where he was.
Lana-ke angizileke ukuthi ngizokhuluma-ke into engasiyona-ke lana kuzokusho-ke ukuthi-ke wayekuphi nendawo leya number egcina ngo-435 kathi-ke ethola i-call. Uma kuwukuthi-ke i-download kanye nayo-ke i-205 yakhe ku-number 5 ngangiyitholile-ke bengizosho-ke ukuthi naye wayekuphi nendawo.
As it please the court, my lord, I'm alerted to the fact that Mr. Mnube quickly want to see me.
Yeah, fine.
Thank you, my lord. Thank you, my lord. Now, just a second. What is that? Just a second, Lord. My papers here, you know, because of the fact that we've got so many papers here. You know, in your endeavor to try and extend this web of fabrication, we are even failing to give this court precise information on which it can rely. And I'm going to demonstrate to you. Let's go to triple K5. Triple K5 and have triple K5C in your possession. Do you have triple K5 and 5C in your possession? I want you to have them side by side, like this, as I'm holding them like this, so that we don't miss
Triple
it.
5?
Triple K in bracket 5 and triple K in bracket 5 in bracket C.
But what's the first one you're referring to?
5.
That is triple K5 in bracket 5.
I don't have a number 5 anymore with me.
Triple K5.
That's the one I handed in, which I write on.
Okay.
Yes, now I got it.
Thank you. Now you see, the information that is contained in this document in relation to the towers differs materially. In 555K, you're saying at some point that number ending with 4358 picked a call when it was at Brett's Scope.
That's correct.
In 555KC, you are saying that number ending with 4358 picked up calls when it was in Rietvlei, in Dompan again, Wolmaranstad, and Wolmaranstad.
That's correct, my lord.
Lana ke ukutshengisa ke ukuthi ke uyaqhubeka ke nalokho ukuthi ke uzokhuluma ke engasikona ke kulama ku triple K5 na triple K5C enye ikhuluma ngeBrets enye ikhuluma nge what's this places iBretscope ikhuluma ngeDoornkop.
Now, I'm not even suggesting, not with an inch, that this information that is contained in here, except that one that I've referred you to, is correct.
It's 100% correct, my lord. You will see the one time is 0047, the
I'm
other
not
one
done.
is 0146.
Colonel Smith, I'm not done. I'm not done. What I want to put to you, I'm not done. Don't rush. I am not suggesting that this other information which is contained in these leaflets here is correct when I only pick up the information relating to the towers. This information that is contained in here, in the broader context of my argument, is also a fabrication. But this is what I want to bring to you. That even the documents, which is triple K5 and triple K5C, the information that you gave there, it's incompatible with each other. In one instance, you're saying the tower that picked up a call by that number 4358 was in Bredscope, whilst on 555 KC, you're referring to the towers at Ritfley, Dompan, another Dompan, and Volmarans. That information is incompatible. That is an endeavor that you're trying to demonstrate that indeed there was a communication between the number ending 202 and the number ending 358. That's just another indication that this is just a fabrication against the holder of that number ending with 202 and the holder of the number ending with 358.
My Lord, this is a section 205. This is a product of Vodacom. Here you see exactly which tower the number was using. So if you take that time, let's say you take 1 o'clock, and you go to the cell phone download and you take 1 o'clock. Then you can use the call made at 1 o'clock on your cell phone download. It's going to be exactly the same as 1 o'clock on the cell phone downloads. Then you're going to make use of the same tower location, because that is where you make a transaction on your phone.
Lemniningwane ke elana ke ibuya ke ku Vodacom bese kuthi lana ke ama downloads uma ubheka lana ke uzothola ke ukuthi ucingo lenziwa ke ngo1 ubusiyobheka nakuleyana ke kuma downloads uzothola ke ukuthi ke ngempela nalapha yana ke ucingo lwenziwa ke noma ke uma bexhumana kwakungo1 isikhathi.
Sorry, for my understanding. He says, Mr. Minister says, all the information in triple K 5C, all of it.
It's not all of it, but
No, he says, I'm trying to understand the logic. He says all of it is fabricated, all of it. It's just that he's picking 2 or 3 aspects of the information, but he says this is a fabrication, all of it. Now, this information, where did you get it from? You, so that they can understand.
From Vodacom. It's a Vodacom product.
Right. In other words, Vodacom was supplied the section 205 document.
That's correct.
So it was about how many pages? 6,000 and what?
It's a lot.
No, yeah. It was 6,229, Mr. Balui. Is that so? Yes. So all the information is there. Is that so?
That's correct, man.
Where's that document? As it is.
I think it's this one.
Yeah. I mean, it's so simple. Then we'll see whether it exists or not. You have the document in your computer.
It's in my computer as well, yes.
Yeah, you can fish it out. You show it to all the councils, and even the state, and even me. This information, where you fished it from.
Yeah. Let me go to the beginning of this document.
Should I proceed, Madam?
No. Let's wait until he gets that.
It's okay.
Do you also have that information, Mr. Balui? Even the councils, all of them, they have the information.
Yes,
All of them.
Yes, we did give it to them on a USB.
So they have it with them. They say you have the information also.
There's a very lot of information, so
Hello?
you don't know what is being referred to here, Madam. There's a whole lot of information.
6,229 pages of section 205 information supplied by Vodacom. And then, according to this witness, Colonel Stein, he fished out that information from that document. According to him, I don't know.
We don't have information, Madam, that we got directly from Vodacom or that was supplied by Vodacom. The information that we're getting is from the state. We're not even so sure whether they gave us right or wrong information.
The disk.
But another thing, Madam, that I also need to bring to the attention of the court.
Yeah.
The court must not, I'm requesting the court not to understand me out of context. I never said,
Better don't say it.
I never said, my lord,
What?
that the information as contained in that 4,649
No,
pages is
you
false.
spoke
I'm
of one page.
specifically referring to
Yeah,
this.
you spoke of one
yes,
page. It's
yes.
me saying this is a product of 6,229 pages.
Yes.
As I'm following the evidence.
Yes.
I listen in court.
And further, my lord,
And then this witness, he says he fished out this information from those 6,229 pages.
yes,
That's all.
My lord, this is the document I received from Vodacom.
What is that?
That is a Section 205 report, statement from them.
ilona ke document engathola ku Vodacom statement ke section 205.
Mr. Badoy, do you have that document?
I think
Yeah, just wait. Hello?
Yes, my lord.
Yeah, can you zoom in onto the same document and then show it to your colleagues here so that there are no secrets. Even Mr. Sibali, do you have that document also?
Yes, my lord, we're preparing it.
Yeah, you got two different computers, is that also? Hello?
No, we're only using one.
One, okay. Mr. Mgomezo, you don't have that document. You don't have it.
I do have it.
Yeah, zoom in on it also.
No, I don't have a computer.
Hello?
I don't have a computer with me.
Oh, you don't have a computer. Mr. Ramosipi, zoom in on the document also.
My lord, I didn't bring my tool.
Mr. Numalo?
I'll do it now.
Hello?
I'll do it now.
Yeah, do it. Mr. Mnisi?
I don't have the facilities, my lord. Where
You
should I
don't
then
have a
zoom it?
computer.
Excuse me?
You don't have a computer.
I do have a computer, but
So-
I don't have it with me
The
now.
document.
The computer. I'll have to check if I do
Yeah,
have-
fine. Ms. Sololo, do you have the computer here?
I don't have the
Okay.
section 205 from Vodacom.
Do you have your computer here?
But another thing, my lords,
Hmm.
this witness is from SABC, it's not from Vodacom. So he's not competent to testify on a document
no.
that comes from Vodacom. That is what the court has always been saying when we wanted to introduce information. Then the court says, no, but this witness cannot testify on that document.
Mr. Mnisi, this is
Yes.
for my own understanding.
Yes, my lord.
Fine. So don't worry about that witness. It's for me.
Therefore, will request, my lord,
What?
that if this witness were to get into this document,
Ah.
I'm going to submit that is not competent. And I'm
Yeah,
aligning that with the reasoning of the
Fine,
court that
fine.
nobody can testify in a document that
Fine,
they did not
fine.
generate.
No problem. Fine.
I'm going to request the court, therefore, to summon an
Miss-
expert from Vodacom to come and
Yes,
testify
fine,
on the
fine.
strength of
we'll
this
call
document.
Pinky again. Pinky and
Yes.
him. Yeah, fine, no
I think
problem.
that will be good, my lord.
But you see, this witness, it's evidence. He says he fished out this information from a document which is in his possession.
Yes.
That's the point.
Yes.
That's the
But
point.
he can't testify on this document. He can't, because this is not his
No, no, no.
creation.
Unless I don't understand English.
My English is very plain. It's simple, my
I
lord.
have 5 courses in English. This witness
Yes,
says
yes,
he fished out this information
yes.
from a document which is in his possession. That's all I want
But
to
the
see.
document that is from Vodacom.
Yes,
It is not
yes.
his document. It is not his document. So he can't testify on a document which is not his.
Well, I'm overruling you.
Thank you, my lord.
Fine. Because all of us are using documents from Vodacom, so I don't see the problem. And you, hello?
Here is the exact page.
Is this the same page like this one?
It's the same page.
No, just, you know what? Let's do it the Mandela way. You see, it says mission, it says number 8 here. At the beginning here. You see that?
Number 8.
Yeah. Where it begins, it says 8.
You're talking about the cell phone number 8, ends with 8.
No. Look. It says 8. Let me just mark this for you. Rose, just give this gentleman this document. Put it, give us, I want him to align it with this.
No, this is for. I think this was really enough.
You see where it begins, the document? There is an 8 there.
That's correct.
Now, I want you to align that document, which you say, it is from where you fished out the document I've just handed you over, which is K 5C.
This is the exact one.
Is that the exact one?
On top, Kimberley.
Nayi-ke le page ekuyona esikhuluma ngayo phezulu bhalwe Kimberley.
It's 22, 48, 46 is the time.
Isikhathi-ke u-22, 48, 46.
Are you able to duplicate that document as it is here?
My Lord, now I must also remember.
I know you took some here, some there.
Yes, yeah. But mine is a combined one of 3 numbers.
Yeah.
The one the state is working on is got only the one of Kelly Kumalo. That's why my page numbers will also differ. But it's exactly the same.
Now I want to see this document.
It's with them.
It is with the.
Yes, yeah. Because I got one with a
No, no,
combined
fine.
3 numbers.
Mina nginayo-ke inamanamba kahlanganisiwe amathathu-ke kodwa-ke abashushisi bona-ke banayo-ke le inale number.
So what you did, you consolidated the numbers.
That's correct, yes.
But in any event, but this information, even if it's consolidated, it's still in that document.
That's in this document.
Are you able to fish it out?
Yes, yeah.
Yeah.
So, cool. That's correctly, exactly the same.
Yeah.
It also starts with an 8 and a 1.
Yeah, fish it out. Fish it, even there, fish it out also. Even the one that is consolidated in your this thing, fish it out also.
Must I read it? Yeah.
No, fish it out. If you read it, I won't understand you. Print it, in other words.
Yeah, but I already got it. This is one of the.
I want it in this format.
That one.
Is this the one?
That's it. That's it.
It's the same one which appears in.
It's the same information because mine is not page. Mine is not page 1767. Mine is page 4711.
Right.
But like I mentioned, I got 2 other numbers in my PDF as
They are
well.
also there.
It's also here.
It incorporates 2 other numbers.
That's correct. Yeah.
So fish out this very document incorporating the 2 other numbers so that it's in one document. Is it possible?
It's possible.
Yeah,
I can do it.
do it.
But I must do it now.
I don't know. Do it now, yeah.
Take mine now.
So must the witness print out that document?
Yeah, for me, so that I can understand. I'm not the type of judge who sits here and pretend I understand when I don't.
Yes, my lord.
Yeah, I don't.
No, thank you.
So for my understanding, it's very important.
No, I think they can only print one copy because we already have copies of those documents.
Which page is that on the screen? Hello? Of the other number?
K5C.
Oh, okay. It's on the screen. Fine. We all have this page. This triple K 5C. Is
Yes,
that not so?
ma'am. Yes.
But what I want the colonel to do, he says when he was working on this document, he was using 2 other numbers.
That's correct, yeah.
So you're using 3 numbers.
No, I didn't. I also used it because the other number was the one of Zandele,
Yeah.
and the other one was the one of Senzo. So I didn't use it. Or I did use it, but it wasn't. I didn't use it because they didn't.
In
find
other
that
words,
number.
this information doesn't appear in the other documents.
It is in this document as well.
Yes, I want to
Yes.
see it.
Okay.
I want to see the origin of the numbers. All the numbers.
Can I print it tonight and give it to you tomorrow?
Yeah, fine. No problem.
No, I do it.
Yeah, do it.
Okay.
You see what I want to understand is the consolidation of these numbers. They obviously don't come from one page. Am I correct?
That's correct, yes.
That's it. So you must come with the explanatory notes, if you have, which must show us how did you compile this
Yes.
document,
Okay. No, I will do that.
and which other numbers did you use to compile this document? You say Zandiles
Yeah,
number,
Senzo.
and who else?
And Senzo.
And Senzo.
That's correct.
So bring all of those documents.
Okay.
And then we shall all sit down here like high school children. You see here where it says 8. When it says 8 in his document, he marks it. And you do the same. Are you with me?
Okay. Yes.
Right. Okay, let's adjourn. What's the time then?
It's 15:05.
15:05.
Yes, without adding the 2 hours.
Yeah. Look at this. There's this aspect. What is it? Are you available tomorrow?
Yes.
Okay. No, there's this other aspect. It just slips my mind now. Just one clarification for me. Did you work in conjunction, in tandem with Ms. Vicky Wallenheim?
Yes,
Think-
yeah, we work together because if I need something, we usually phone
On
them.
the very same documents?
Yeah, she was the one who handled the section 205 at Vodacom.
Okay, can you get Ms.
Pinky.
Pinky Tullingham to come also, if you can.
Tomorrow.
But I'm going to call her to come also, to come and explain how they compile. Because they say she can't testify on the document of Vodacom. Or he can't testify on the document of Vodacom.
But I got that from the court, my lord. It doesn't come from me. You remember the court when I wanted to take up an issue with Mr. House, Colonel House, on Vodacom's document, all the information that was compiled by by Ms. Vitilingam. Then the court says, no, Mr. Amnesty, you can't do that because this witness can't testify on the strength of a document that has not been penned by him. The person who penned that document must come testify. So I'm using that same analogy.
That's true. And the person who
Thank
penned
you,
this
my lord.
document, XXXK 5C, it's
Yes.
this witness. Am I correct, sir?
Yes,
That's
but
the point.
but it's a product I received from Vodacom.
That's it, but you compiled it.
I only print the page.
That's
No,
it.
he
Okay,
printed
fine.
it, my lord.
Yeah, fine, no problem.
Yes.
We'll call even Pinky to come.
Thank you, my lord.
The truths are out.
I wanted to continue.
No, let's
I
adjourn.
can't, my lord.
I'm doing what you guys do,
Thank you, my lord.
which actually is not correct.
Yes.
When you have a dispute with a witness, you want the court to stop and you want to listen to the machine. It never happens anywhere in the world, except here.
That is correct, my lord.
Okay,
but
well,
the
you've heard me.
procedure is,
You've heard me.
at least
You've
the
heard me.
court should then have regard to the record and say, in terms of the record that I have, this is how this thing is captured. But if I still don't agree with the court, then the record is the final ubita.
No.
Yes.
If you go to the Constitutional Court and you argue like that, they will tell you refer to the page. Or you go to the SCA, they will tell you that.
Yes,
They
ma'am.
don't stop the machine. Have you ever heard that? In the Constitutional Court, they stop machine and then zondo.
No, but at the
Listen.
Constitutional Court, my lord, the record is already
They don't
available.
do that.
At the Constitutional
Okay,
Court
can
and
you-
the SCA, the court is already
Can you
available.
accept?